task is to try the perpetrators of the Rwandan tragedy, to punish those found guilty, and thereby to deliver a message strong enough to discourage any thought of a repetition of such heinous acts by anyone, anywhere. The international community, anxious to palliate the worst excesses of dictatorship, had already established the Nuremberg and Tokyo tribunals in the aftermath of the Second World War. Another tribunal was established in 1993 to try offenders in respect of the former Yugoslavia. The International Criminal Tribunal for Rwanda, established a year later, is therefore the fourth of its kind. On this occasion, the international community has sought to identify the causes and understand the reasons for such heinous acts, and hence to contribute towards the reconciliation of the Rwandan people. Some months earlier, on a grey April morning shrouded in mist, Rwanda awoke to an apocalyptic atmosphere. God had deserted Rwanda the day before and would not return for 100 days. 100 days that the Rwandan cataclysm lasted. Between 800,000 and a million people dead. The tragedy plunged the entire country into mourning, and the whole African continent was affected. Millions of Rwandans were forced into exile. Never in human memory had killing occurred on such a scale, in such a short time, and with such crude weapons. No one was spared, neither women, nor children, nor the elderly. The country of 1,000 hills was a vast burial ground. Death and devastation were everywhere. Rwanda had foundered in unspeakable horror. After establishing the tribunal, the Security Council decided to locate it in Arusha. A small town at the foot of Mount Meru in northwest Tanzania, not far from Mount Kilimanjaro, famous for its eternal snows. Arusha has approximately 200,000 inhabitants and is better known for its mild climate and easy access routes for safaris to the Serengeti, Manyara, and Ngorongoro parks than for its communications infrastructure. The office of the prosecutor was established in Kigali, the capital of Rwanda.
Good afternoon. How are you?
In order to facilitate investigations in general and of the sites of massacres in particular, as well as to facilitate the search for witnesses. The former headquarters of the United Nations Assistance Mission in Rwanda, known as UNAMIR, near the stadium and the airport, provided premises to house that office.
Le staff du procureur travaille
The prosecutor's staff work in Kigali in close cooperation with the people of the area, and in any case with those in the field. We are unable to do this, which seems to me to be a significant difference in our capacity and efficiency.
d'efficacité.
There is definitely inequality of treatment as regards the resources at the disposal of the defense and those provided to the office of the prosecutor. Here we are in my office. You will see. The computer is totally obsolete. Access to the internet is a matter of luck with this one. Yet they have an extraordinary, extremely interesting data bank called TRIM, by which any information can be found. We used to have access to it, but now we don't.
La défense doit se rendre compte d'une chose. The defense should realize one thing. A lawyer is, first and foremost, an independent agent. We do not want defense lawyers to be civil servants like the jurists in the office of the prosecutor. And when we talk about equality of arms, the idea is not to say, yes, there is a budget, let us say, of, I'm advancing a figure of $25 million for the office of the prosecutor, so there should be $25 million for the defense. No, that's not what is meant by equality of arms. Equality of arms is provided for in the legal and statutory instruments to ensure that the defense plays its role fully and with full regard for the rights of the accused.
The tribunal's beginning in 1996 was not easy. Arusha lacked the adequate infrastructure to host such an institution and all its requirements. Everything had to be built up from scratch, including satellite communication links, offices for the court officials, as well as the courtrooms where the trials would be held.
Well, I must say I received a big shock too. I am from South Africa, so the then registrar, Mr. Adeda, in the company of the then prosecutor, Judge Richard Goldstone, called me and said, well, since I'm the closest, can I come over to hear the first confirmation proceedings of the first indictment. And I was really shocked. There was no building, there was nothing, there was no court. We sat in the hotel room. We worked with the typewriter of the manager of the hotel, with the typist who couldn't type. So at a borrowed table and borrowed chairs in an office, and with a quickly wooden carved stamp, I signed and issued the first indictment.
Three distinct and complementary organs constitute the tribunal. The chambers, including the appeals chamber, which is common to the ICTR and the ICTY, and three trial chambers. The office of the prosecutor, headed by the prosecutor, who is also common to the two ad hoc tribunals, and the registry, headed by the registrar, who is in charge of the administrative, financial and personnel matters. The registrar is also responsible for providing judicial support to the trial chambers and the parties. Within the registry, one very important section deals with witness protection and is responsible, inter alia, for bringing witnesses to Arusha and providing them with the necessary security and psychological support to enable them to testify before the trial chambers.
A certain measure of protection must be given to these witnesses. It is necessary to ensure that after their testimony, neither defense nor prosecution witnesses are either harassed or persecuted by anybody whatsoever.
The reality of the tribunal was made clear to the first accused persons to make their initial appearances before it. There were three in the dock. Their initial appearance took place in a room provided by the Arusha International Conference Centre, which hosts the tribunal. It was a cramped room not intended for such purposes, that had been hastily adapted.
The Trial Chamber 1 of the International Criminal Tribunal for Rwanda, composed of Judge Lete Kama, presiding judge, Judge Leonard Aspigren, and Judge Nevanet Dempile, is now in session.
Do you plead guilty to crime against humanity, murder? Do you plead guilty or not guilty? The proceedings are adjourned.
George Rutaganda, Clement Kaishema, and Obed Ruzindana entered pleas of not guilty in the presence of their counsel, duly assigned by the registrar. Those three accused persons were also the first to be detained at the detention unit, which was then still under construction. Its 56 cells were completed soon afterwards and now house nearly 60 detainees.
Le peuple l'acclamait beaucoup, ce ne sont pas les pharisiens qu'on a acclamé. C'est pour cela que le Christ pleure sur Jérusalem.
At visiting times, the accused and their assigned counsel consult and prepare their cases in the visiting rooms. The unit is the first of its kind to be built and managed by the United Nations. It's under the authority of a commander responsible for ensuring discipline and the observance of the rules governing a prison establishment. Several high-ranking officials of the former Rwandan regime, including civilians, military officers and clergymen, are among the detainees. On 9th of January 1997, the trial of the former mayor of Taba, Jean-Paul Akayesu, opened in the sole courtroom available at that time. The accused appeared before the bench of Trial Chamber 1, presided over by Judge Leiti Kama of Senegal, assisted by Judges Nvanathan Pillay of South Africa and Lennart Aspergren of Sweden. Jean-Paul Akayesu was subsequently found guilty of genocide and sentenced to life imprisonment, the maximum sentence that the tribunal can impose. The verdict, the first to be delivered in matters of genocide by an international court, was upheld in due course by the appeals chamber. In their judgment, Judge Leiti Kama and his colleagues called genocide the crime of crimes. They went further and extended the definition of genocide to include sexual assault and rape, henceforth considered constitutive elements of the crime of genocide.
It's the first time in history that an international court delivered a decision on genocide since the Genocide Convention was passed in 1949. And the other feature about that case is that for the very first time, once again, rape was found to constitute the crime of genocide, because in that case there was evidence that Tutsi women were being targeted with the intention of causing the destruction of the Tutsi group as a whole. Akayesu did not personally commit any acts of killings or rape or other atrocities. So that's the other very important feature, that even though he personally didn't commit the acts, he was held responsible because he's a superior officer.
In the meantime, the highest-ranking politician to be detained by the tribunal, the leader of the interim government of Rwanda in 1994, former Prime Minister Jean Kambanda, admitted his responsibility in the genocide at his initial appearance in open court.
In the evening of the 8th of April 1994, a jeep, an army jeep with soldiers, fetched him from his house, took him to the École Supérieure Militaire, where he was told by top brass of the military that he was nominated Prime Minister. The accused was trapped and was made a puppet, a marionette. Upon his arrest in Nairobi, Kenya, the accused confessed his guilt and decided to plead guilty before any tribunal.
It's the 1st of May 1998, and the media and public came in large numbers.
It was then that he felt at ease and free. The incubus had been lifted and sent away.
On 29th of February 1998, a few months earlier, the former commander of the United Nations Assistance Mission in Rwanda, the Canadian General Romeo Dallaire, testified before Trial Chamber 1. His testimony still remains one of the high points in the history of the tribunal.
It has always been very easy to accuse the United Nations of not having intervened, but the United Nations is not a sovereign country. All of us make up the United Nations.
During the press conference that followed, the general recalled his experience. "I know that God exists because I met the devil." A few months later, on 6th of May 1998, a large crowd attended the visit to the tribunal made by the United Nations Secretary General, Kofi Annan. During his visit, the Secretary General expressed his personal support for measures to accelerate the work of the tribunal towards the fulfillment of its mandate.
Trial Chamber 1 is in session today to pronounce sentence in the matter of the prosecutor against Jean Kambanda.
Jean Kambanda reconnaît.
Jean Kambanda acknowledges that following numerous meetings of the Council of Ministers between 8 April 1994 and 17 July 1994, he as Prime Minister instigated, aided and abetted the prefets, bookmaster and members of the population to commit massacres and killings of civilians, in particular Tutsi and moderate Hutu. Count 9. Jean Kambanda acknowledges that on 3 May 1994, he was personally asked to take steps to protect children who had survived the massacre at the hospital, and he failed to act. On the same day after the meeting, the children were killed. He acknowledges that he failed in his duty to ensure the safety of the children and of the population of Rwanda. Count 10. Jean Kambanda admits that in his particular role of making public commitments on behalf of the government, he addressed public meetings and the media at various places in Rwanda, directly and publicly inciting the population to commit acts of violence against Tutsi and moderate Hutu. He acknowledges uttering the incendiary phrase that was repeatedly broadcast, quote, "You refuse to give your blood to your country, and the dogs drink it for nothing," unquote. I now call on Jean Kambanda to stand up and to hear the sentence.
La Chambre de première instance
Trial Chamber 1
condamne Jean Kambanda.
Sentences Jean Kambanda, born on 19 October 1955 in Gishamfu, Commune, Butare Prefecture, Rwanda, to life imprisonment.
Il en est ainsi décidé.
It is so decided. Jean Kambanda may now leave the court. The proceedings are adjourned.
L'audience est levée.
All rise. He later retracted his confession and appealed against the judgment.
La Chambre d'appel, siégeant en audience publique,
The appeals chamber, sitting in open session, unanimously dismisses the 8 grounds of appeal lodged against the judgment of 4 September 1998 by Trial Chamber 1, confirms Jean Kambanda's guilt on all the counts, confirms the sentence of life imprisonment. The hearing is closed.
Veuillez vous lever. All rise.
On 19th of October 2000, Jean Kambanda made history as the first head of government to be sentenced for crimes of genocide.
We also discussed our ongoing activities in
For the prosecutor of the 2 international tribunals, Louise Arbour of Canada, and her deputy Bernard Muna from Cameroon, That was a marked accomplishment.
Regarding Kosovo,
For the first time in history, an international court had received the confession of a head of government and convicted him. Arusha became the subject of world attention.
last week,
For Arbor and Muna, there had been other successes. Some time earlier, they had brought off a masterstroke. On the 18th of July 1997 in Nairobi, with the help of the Kenyan authorities, they had succeeded in arresting many of the high-ranking officials of the former regime, including Jean Kambanda himself. Most of the construction work that had been undertaken was completed by 1999. Now, not just one, but 3 ultra-modern courtrooms are ready.
Crime I may have allegedly committed.
A state-of-the-art law library welcomed its first users. And a fully equipped press room is at the disposal of journalists.
Plaidez-vous coupable ou non coupable?
Je plaide non coupable, Monsieur le Président.
Non coupable, votre honneur.
Je plaiderai non coupable puisque ce sont des pires mensonges, Monsieur le Président.
Despite John Kambanda's confession, former ministers of his government and certain high-ranking officials of that regime protested, and still protest, their innocence. It was a former leader of the Interahamwe militia, Omar Serushago, who broke the trend. At his initial appearance, he surprised everyone by pleading guilty. His confession earned him the leniency of the judges.
Premièrement, l'appel est rejeté.
First of all, the appeal is dismissed. Secondly, the sentence handed down on 5 February 1999 by Trial Chamber 1 is confirmed.
Confirmé.
He was sentenced to 15 years imprisonment. In September 1999, after 3 years spent pursuing those responsible for the Rwandan genocide and the former Yugoslavian war criminals, Louise Arbour resigned as prosecutor, having been called to the bench of the Canadian Supreme Court. In 1996, she had succeeded the South African judge Richard Goldstone, first prosecutor of the 2 United Nations ad hoc tribunals. The Security Council then appointed Carla Del Ponte, a Swiss national, to succeed Mrs. Arbour. Together, Bernard Muna and Carla Del Ponte sought and obtained the joinder of all accused persons implicated in crimes committed together in a series of joint trials. That strategy of joining several cases was designed to enable the Office of the Prosecutor to establish that there had been a long-standing conspiracy on the part of the accused to commit the genocide.
Naturally, that's not the miracle solution, but in any case, it's a means of expediting the proceedings. Furthermore, if the charges are based on the same facts, it's really more appropriate that all the accused should be jointly tried.
Since the tribunal's inception, its relations with the government of Rwanda have not always been ideal. The Rwandan authorities blow hot and cold. On the negative side, the criticisms of Ibuka, an association of genocide survivors, and Avega, the Association of Genocide Widows, are among the most severe.
Quand on a à cœur de défendre les victimes, il arrive.
When one is very keen to defend victims, one may sometimes not understand certain situations, and I'm referring here to the situation of witness victims who appeared, and in the end there were allegations of ill treatment. Allegations which the registrar is investigating and will continue to investigate.
I think
that is inherent in the system. If it were a civil law system with an examining magistrate, there would have been a neutral person in the middle who would compare what the witness is saying to what he really did. There would have been rogatory commissions where there would have been some form of verification. At this tribunal, you are told that each party brings its own witnesses, so you haven't the slightest clue whether the witness is telling the truth or lying through his teeth, as is sometimes the case. We are therefore forced to do the job the examining magistrate would have done in our system, and we are forced to push the witnesses. At any rate, when our witnesses testify, the prosecutor subjects them to the same treatment.
The procedure and conduct of trials are designed and organized as if the proceedings were between the international community and the accused persons. No place, voice or representation is given to the victim. It is absolutely normal that after the observations we have been making since the creation of the tribunal, the results obtained have shown that the absence of a place for the victim is a serious drawback.
Je trouve que
I believe that if there are any trials where victims need to be represented, it is indeed the trials we are conducting here. Trials involving genocide and crimes against humanity. And I believe that the fact that they are not represented is a flaw, a major flaw in international justice.
In a criminal case, it's a prosecutor who represents the interests of the victims, or because they are his witnesses. So whether it's witnesses for the prosecution or witnesses for the defense, they're all victims. They've all suffered in one way or another. They've lost families. The court has to protect the rights of all these victims, of all these witnesses. And to do so, the tribunal has the witness and victims protection services. One section for prosecution witnesses, one for defense witnesses.
Je suis très sensible au sort des
I am
victimes.
very concerned about the fate of genocide victims, and it is regrettable that during the adoption of the statute for the creation of the International Criminal Tribunal for Rwanda, the Security Council did not make specific provision for the role and place of victims within this tribunal. The Treaty of Rome that set up the International Criminal Court has certainly corrected the situation. But all we can do is provide additional resources to assist the victims, even if it is only by way of compensation. And, as you are no doubt aware, even that does not fall within the tribunal's jurisdiction.
The appeals chamber of the International Criminal
The
Tribunal
low point in the lukewarm relationship between the Rwandan authorities and the tribunal came when the appeals chamber decided that Jean Bosco Barriaguiza had been unlawfully detained for 18 months in Cameroon before his transfer to Arusha and should be released. Barriaguiza was the former director of political affairs at the Ministry of Foreign Affairs of Rwanda and one of the founders of the Radio-Télévision Libre des Mille Collines. The newly appointed prosecutor, Carla Del Ponte, requested a review of the judgment.
Il y a un peu plus de mois et demi que j'étais procureur au parquet de ce
I had been the prosecutor for this tribunal for a little over 2 months when the Barriaguiza decision landed on my desk. Let us be clear, acquitting an accused because of formal or procedural defects or for abuse of process is actually provided for. But to forbid a prosecutor from prosecuting was something new to me. Your Honors, the prosecutor is humbly asking you to reverse that decision. In fact, I am the only person representing the victims here, and on their behalf, I am asking you to allow the prosecutor to institute proceedings against Barriaguiza, who was accused of genocide and crimes against humanity, and whose indictment was confirmed. He is therefore no longer a suspect. He is an accused. Whether we like it or not, due account has to be taken of the fact that we depend on the government of Rwanda to continue our investigations and to conduct our trials. Were Barriaguiza not to be tried by this tribunal, the only alternative would be to hand him over to the state of Rwanda, or else, I fear, as we say in Italian, possiamo chiudere la baracca. We can close down the shop.
Possiamo chiudere la baracca. On peut fermer la porte.
In my country,
the Rwandan authorities dispatched the country's Attorney General, Gerald Gahima, to appear as amicus curiae to defend the position of his government.
Of victims of sexual violence and other victims.
Jean Bosco Barriaguiza was kept in prison until the chamber gave its decision.
It's inconceivable to them that someone can be released on technical grounds, on procedural
Our complaint was that the tribunal was setting him free without trying him because of procedural irregularities, like the delays in bringing him to trial. Now, we, the people of Rwanda, we are not the ones who delayed his trial. It's the tribunal. So we do not feel he should be set free because of the mistakes of the tribunal's personnel.
On account of which we believe that the appearance...
Carla Del Ponte's first contact with Rwanda was a failure. The prosecutor could not go to Kigali, or rather she could, but would not be received by the Rwandan authorities.
By the resolution of the Security Council in bringing
At best, she could meet her own staff in the Kigali office.
Which this tribunal was established to adjudicate.
Si cette cour a décidé de libérer l'appelant avec préjudice, c'est parce qu'elle a voulu le dire. Maintenant, ce qu'elle fait, ce que le procureur peut faire ultérieurement, c'est à elle de le décider. Mais la Cour a tranché la question. Et à mon avis, cette Cour est functus officio.
Il y a une procédure de révision qui est prévue.
There is a review procedure provided for the accused, or the prosecutor may find new facts that were not raised in the appeals proceedings. A review of the decision may therefore be requested.
Peut donc demander la révision de la décision.
The appeals chamber reconsidered its decision and decided not to release Jean Bosco Barriaguiza. In order to expedite trial proceedings and silence the critics, President Laity Kama requested the General Assembly to authorize the creation of a third trial chamber. The tribunal at first had 6 judges who sat in 2 trial chambers, all of whom were elected in May 1995 for a 4-year term. The other 5 judges were Judge Navanathan Pillay from South Africa, Judge William Sekule from Tanzania, the presiding judge of Trial Chamber 2, Judge Lennart Aspegren from Sweden, Judge Yakov Ostrovsky from Russia, and Judge Tafazal Hossein Khan from Bangladesh. The election by the United Nations General Assembly of the judges for the new trial chamber took place at the same time as the renewal of the mandate of the first team of judges, 2 of whom, Judge Aspegren and Judge Khan, did not seek renewal of their mandates. The other 4 judges were re-elected for a second 4-year term. Shortly afterwards, 5 new judges were elected. Lloyd George Williams from St Kitts and Nevis, Pavel Dolenc from Slovenia, Eric Mercer from Norway, Mehmet Gune from Turkey, and Dionysios Kondilis of Greece. The latter resigned a month later for personal reasons, whereupon the United Nations Secretary-General appointed Asoka Desoisa Gunawardana from Sri Lanka. The tribunal then numbered 14 judges, sitting in 3 trial chambers, composed of 3 judges each, and an appeals chamber made up of 5 judges. No 2 of the judges may have the same nationality. The appeals chamber, which is common to the 2 ad hoc tribunals, is presided over by Judge Claude Jourda of France. He had followed Judge Gabriel Kirk MacDonald from the United States, who in turn was the successor of Antonio Cassese of Italy. On the 25th of September 2000, an information centre was inaugurated in Kigali as part of a public information and awareness project known as the Outreach Programme. The centre is called Umusanzu mu Bwiyunge, which in Kinyarwanda means contribution to reconciliation. The centre houses a public information service, a library of reference material on international criminal law and the case law of the tribunal. It's intended as a venue for the exchange of ideas and above all to inform and sensitize Rwandan citizens on the accomplishments of the tribunal and thus to contribute to national reconciliation.
Considering the general practice regarding prison sentences in Rwanda, considering that George Rutaganda has been found guilty of genocide, count 1, crime against humanity, exterminations.
George Rutaganda, a former leader of the Interahamwe militia in the Kigali region,
for all the counts,
Alfred Musema, and several other leaders were found guilty and sentenced to life imprisonment by Trial Chamber 1.
Sentences George Rutaganda to a single sentence of life imprisonment for all the counts on which he has been found guilty.
Trial Chamber 2, presided by Judge William Sekule of Tanzania, for its part successfully concluded the first ICTR joint trial. That was the trial of Clement Kayishema, the former prefect of Kibuye, and Obed Ruzindana, a former Kibuye-based businessman.
Vous n'aviez pas d'uniforme de préfet.
They were sentenced to life and to 25 years respectively.
Selon Kayishema,
the appeals chamber has since upheld both sentences.
Dès lors, je cite, que le procureur s'est rendu lui-même sur les lieux et pas les conseils.
Vous pouvez vous asseoir.
On the 6th of October 2000, one of the most important ICTR trials began. It was the joint trial of 3 accused who are all former leaders of the Rwandan media. Jean Bosco Bariagwiza, whom the appeals chamber had ordered to be kept in detention, Hassan Ngeze, former editor of Kangura newspaper, and Ferdinand Nahimana, former director of RTLM radio station. They were to have been joined in the dock by a 4th accused, George Rudju, a Belgian former RTLM journalist. He is the only non-Rwandan to be accused of genocide, and, after first denying that he had participated in the massacres, he later changed his plea and entered a plea of guilty. He has since testified against his former bosses.
Legions Belgium 2, count 1, direct and public incitement to commit genocide, a term of 12 years imprisonment. And on count 2, crime against humanity persecution, a term of 12 years imprisonment. You shall serve these 2 sentences concurrently.
The atmosphere at the beginning of the media trial was tense. Jean Bosco Bariagwiza and Hassan Ngeze each dismissed their counsel and refused to appear.
Mon arrivée au centre de détention ce matin à 07h45, j'ai moi-même été voir.
Upon my arrival on duty at 7:45 this morning, I personally went and saw the detainee, Jean Bosco Bariagwiza, and asked him to get prepared to go to court. And on 3 occasions he said no, he would not appear in court, and that his lawyers would explain his reasons to the court.
Vous comprendrez que notre client s'exprime en ce sens qu'il est impossible pour lui de subir un procès juste et équitable devant ce tribunal qui, en d'autres mots, est en quelque sorte dirigé, pour reprendre les termes de mon client, par le régime de Kigali.
You have been appointed to look after the interests of Mr. Bariagwiza. We all hope that he will reconsider his decision and attend court because it's of crucial importance to him.
He sought to kill children, women, babies, innocent civilians, and his microphone to call for genocide.
The trial started nonetheless. Trial Chamber 1, presided by Judge Pillay, who had succeeded Judge Kama as the president of the tribunal, and her colleagues were ready to hear the first witnesses.
As powerful managers of the written press and the radio. The radio quickly announced the death of the president and put the blame firmly and squarely on the FPR and the Tutsis. By the morning of the 7th, the streets of Kigali were already littered with bodies of Tutsis and Hutu moderates. The genocide of the Tutsis and the extermination of the Hutu moderates, long planned, had now begun.
Le discours de l'accusation aujourd'hui.
The language of the prosecution today is a departure from the law. Indeed, has it ever been close to the law?
Pour donner, dans une approche politique,
it is more political, more ideological, and closer to propaganda, both in terms of its content and methods.
avec les moyens de la propagande. Nous avons vu sur nos écrans.
While prosecution counsel Mr. Muna was talking of something else, we saw images on our monitors but did not know where they came from.
Je suis inquiet qu'aujourd'hui le parquet
I am worried that today the prosecution has confused the issues, using oversimplification and manipulation. In other words, the prosecution today used methods for which it reproaches the accused.
Il reproche à ceux qu'il poursuit.
Freedom of the press is on trial in this courtroom. Defense disagrees mightily with the prosecution when they say that this is a simple case. It's not a simple case. This is a landmark case. This is one of the most important cases to come before mankind because what's on trial here is freedom of the press. Intellectual freedom is on trial in this chamber.
Investigations and arrests continue. Although there is no international police force and the support of some states continues to fall short, the tribunal's investigators continue to tirelessly track suspects.
Pour obtenir l'arrestation, on n'a pas vraiment un moyen de pression. Naturellement,
we have no real way to exercise pressure to bring prosecutions. The only thing we can do is to sensitize the international community that set up this tribunal, that the tribunal can do its work only if it conducts trials, and that trials can be conducted only if people are arrested. It is therefore the duty of the international community to bring pressure to bear on states in order for them to cooperate, especially in arresting the accused and the other coercive measures that we could ask for.
Do you want some time?
The interest of the international community seems more focused on the other tribunal, the one dealing with the crimes committed in the former Yugoslavia.
I consider this tribunal a false tribunal and indictments false indictments.
Had the Arusha tribunal been based in The Hague, it would have received wider media coverage. It would certainly have been given much wider publicity, for let us not forget that it was the Arusha tribunal which was the first to try head of government in the person of Jean Kambanda.
After the first convictions were upheld, it was time to make arrangements for the execution of sentences. It's not enough only to convict, but the prisoners have to be incarcerated. On the 12th of February 1999, the registrar of the tribunal, then Agu Ukali from Nigeria, signed a first cooperation agreement with Mali. On 26th of August 1999, a similar agreement was signed with Benin. 1 year later, on the 30th of August 2000, Swaziland in turn signed a cooperation agreement and committed itself, like the other two signatory states, to host the convicted persons for the duration of their imprisonment. At the end of February 2001, after a 4-year mandate as registrar of the tribunal, Agu Okali, who had succeeded the tribunal's first registrar, Androniko Odede of Kenya, also left. The United Nations Secretary-General appointed Adama Dieng of Senegal to replace him. At the time he assumed office, the tribunal was undergoing important changes. Some months later, the deputy prosecutor, Bernard Muna, who had replaced Rakoto Manana from Madagascar, had also left the tribunal after 4 years at the head of the prosecutor's office in Kigali. The new registrar, a seasoned diplomat with wide experience of negotiating, first took up the task of consolidating relationships with member states.
Je déclare solennellement que je remplirai mes devoirs.
I solemnly declare that
The new registrar arrived just before the election by the United Nations General Assembly of 2 new judges, Arlette Ramoroson from Madagascar and Winston Churchill Makutu from Lesotho.
of the International Criminal Tribunal.
Monsieur le représentant du greffe, veuillez
The Secretary General subsequently appointed Andrésia Vaz of Senegal to succeed Judge Leyti Kama, who had passed away in early May 2001.